Hello everyone, I'm back. We'll try and pick up from where we left off, which is to find ways to review a contractual document and also try and understand how it links back to the theory we learnt in law school. Going back to the theory first, the easiest one to find is consideration, which could be mentioned as charges or rates or compensation depending on the nature and language of the contract. In other words, find out who's paying whom, how much, and for what. Another simple one is capacity, which is linked to the parties to the contract. Majority of business contracts are between legal persons, like a company, and not so much with human beings or natural persons. Other than certain obvious exceptions like employment contracts, of course. The diligence behind capacity is different based on legal person and natural person. We will talk about this in detail later. For offer and acceptance, you can look at the initial section called recitals or preamble or background in the contractual document, which talks about one party offering and the other one accepting. It might even be absent in certain contractual documents, but that does not invalidate the contract. The reason lawyers are not too worried in the practical world about offer and acceptance is that most contracts are signed by both parties for good business practice. Later, we will also talk about whether a contract needs to be signed and why do we have these practices. Going to the next one, legality. That can be found in the scope or purpose of the contract. In other words, for what is the contract being made? We will come back to the others as well, like meeting of minds, intention, certainty, etc., which are easier to understand once we get into the drafting of a contract. Now, on trying to get one's head around reviewing of a contract, everyone finds their own way, of course, but one of the most popular ways is to skim through the document and try and find out what exactly is happening. As an example, is it a contract where services are being provided? Or is it a contract where services are being utilized? Then, the next step is, what services are they? Then, try and think of what's relevant from your side. Let's try and take an example again, this time of a business environment. A lot of us review service contracts from vendors. If we are taking services for the vendor to come to the office premises and maintain an existing equipment, what would be essential for that? To start with, we should try and find out if it's only preventive maintenance or only remedial maintenance or both. For preventive, how frequently would they visit? For remedial, is there a promised turnaround time? Do they cover spare parts? If not, do you procure it or do they procure it and charge it to you? If they procure, is there a warranty to those spare parts? If they don't do the services as per the promises, do they give back service credits? If yes, how would those be calculated? Are you okay with them to use a subcontractor or not? Can you use another vendor or is this arrangement exclusive? How are you reducing the potential risks from their visits to the premises? What are the measures from their side to ensure safety and prevent incidents? The list goes on. Unfortunately, there is no set structure on where to find it. This content could be spread across obligations, covenants, representations and warranties, responsibilities, duties, liability, indemnity, and even general terms and conditions. I'm sure you're thinking as to how a lawyer would know this level of detail of operations. Well, this information would be available to the relevant team talking to the vendor, and usually it would be an operational department. Of course, it takes a bit of experience to understand what questions to ask, so there is nothing to worry about if this seemed a bit overwhelming for those who are just starting out. We will talk about the practices and ways to procure this information in other sessions. We'll meet you soon. Thank you so much for your time.